Hi everybody, this is attorney Brooke Goff of Goff Law Group. I'm doing one of these videos. It comes by high demand actually. Introduction to workers' compensation in Connecticut. Now I do several of these videos and some of the information may seem a little redundant. However, I always take the questions I received after the videos and I kind of weave them in. And I also review the videos and see how I better could have explained, okay, well, this person had this issue or this person had this issue. Let's try to fix it. Firstly, this is just going to be literally an introduction, okay? This is not in any way, shape, or form the entire lifespan of a case. I'm not even in this, I can only cover so much in one video, but I'm not even going to cover like what happens when things go bad, et cetera, et cetera. I'll do that in another segment. But for this segment, it's just introduction to workers' compensation in Connecticut, period. Now, a bit about my firm. I am the founding partner of Goff Law Group. We are a personal injury / workers' compensation law firm in Connecticut. Offices throughout the state. We service the entire state of Connecticut. I am in Norwich some days and I'm in Stamford other days. So we literally do the entire state. And we're one of the only law firms left that do just personal injury and workers' comp and not divorce and real estate and everything else. It's my opinion that because we do that, it's what makes us so good, right? So jack of all trades, master of none is not my style. I like to be really good at something, grab something by the horns and master and own it and be able to serve my clients effectively and diligently. All right, so that's a little bit quick intro about my firm, what we do. And at the end of this, I'll tell you how you can contact me if you choose to do so or think I could be a help for you. Because I'm going to tell you what I should name this is Introduction to Workers' Compensation Connecticut, AKA why you should hire a lawyer. I don't do this to get business. I get business in full disclosure? Of course I do. But I don't do this to get business. I do this because I want to educate people. And by educating people, you give them power, right? And the power of decision and being able to make an educated decision is so key. And most people don't have it when they're injured or they're faced with some sort of a horrific event or traumatic event in their life. I will tell you this. When people come in my office, I want them to hire me because they want me, because I educate them and then they know what they're facing without me. I don't want people to hire me on need. I want them to hire me because they want me. And if my clients do that, it tends to lend itself to a much better relationship between client and lawyer. And it also works best in your interest because you at the end of the day don't think, should I have gotten a lawyer or should I have hired that lawyer or did I hire the right lawyer? I'll tell you, when people hire me, they don't question their decision. They don't. And it's because my firm, all of us, I have a workers' compensation group. My law partner, Norma, co-shares that with me. And let me tell you, we do amazing things every day. We win cases. We settle the unsettleable. We take cases that people turn down. And like I said, we win. And we do that because we take what we do very seriously and personally, which most attorneys these days lack that personal aspect of it. We're people. We're not stuffy suits. And people like that about us, especially somebody that's hurt at work. The last thing you want is to walk into an attorney's office and make them feel like they're better than you just because they have a law degree. I'm not any better than the mason that comes in that hurt himself when he was practicing masonry, the massage therapist that has repetitive motion trauma and now has carpal tunnels of the hands. The construction worker that fell off a ladder, the electrician that got electrocuted. I'm not any better than them because at their job, they're better than me, right? And I know the law. That's what I do. So I tell people, in the event that you had a problem medically, would you try to take care of it yourself or would you go to the hospital or doctor? Probably go to the hospital or doctor, right? If you're bleeding out of the leg, you're going to go to a hospital or doctor. I tell people, take that same mentality with legal. Why are you going to handle it yourself? Unless you don't know what you are giving up, not having a lawyer, which is what I'm here to tell you. And the other aspect of it you should know is all my consultations are free. And we only get paid if we win your case. And that's the way it is. It's 20%. It's set by statute. No need to window shop, okay? Some attorneys actually do charge 25%. We don't. I think it's unethical. So there's no need we take the window shopping out of it. It's 20%. Every attorney you talk to will either be 20% or 25%. So there's no fee unless we recover at the end. And on average, in a comp case, we don't get paid for at least a year. So all those hearings, all the work on the file, all the client communication, all the checks we get, all this other stuff that we put into the file, we don't recover on that for at least a year. So that's my gist. A lot of people ask me these questions after the fact, so I'm covering that first. Okay, so you're hurt at work. What do you do? Well, the obvious is clearly tell your employer when you're hurt, okay? If it's not a life-altering emergency, you need to report it to your employer within 24 hours. Don't just walk up off the job and leave and then drive to the hospital, okay? Tell your employer, hey, look, I was hurt. I need to go to the hospital. Because the last thing you want is me to be in workers' comp 3 or 4 weeks down the line, or yourself to be in workers' comp and have them say, hey, look, you never reported it. Couldn't have happened at work. You don't want to borrow that problem because you're only borrowing exactly that problem. So what you want to do is obviously get medical attention immediately if it's medically necessary, and report it to your employer. I'd say if there's no employer around, if you are like a truck driver, whatever the case might be, call it in. If you can't call it in because there's a medical emergency, let them know within 24 hours, okay? Make sure you tell the hospital staff and or the doctor that you go to see, hey, look, this is a result from an injury at work. I was injured and I need treatment. Tell them how you're injured. The more specific you can be, the better. In that, these are the things that come back later and bite you, okay? Be specific. Don't lie to the medical providers and say, oh, having a home because you're afraid of losing your job. We'll cover that in another segment. Be honest, because I'm telling you right now, you are ruining your chances of having a successful comp claim and making it much more difficult for you to collect and buying yourself a delay in payments if you're not truthful from the onset. Report it to your employer, okay? Within 24 hours, if it's a medical emergency, go to the hospital, and of course, report it to your employer within 24 hours. And then, obviously make sure that you keep in touch with your employer about whether or not the hospital kept you out for 3 days. Don't just not show up for work, guys. You have got to be in contact with your employer. Now, what do, right? Now you're hurt at work, you're now home, you're you think you're kept out of work for 5 days, you don't know what to do. First thing you're gonna do is file a 30C, okay? Now, I'm going to show you this is the workers' compensation. I know it's backwards. I can't fix that. This is the workers' compensation book. They change every year. This is 2019. You can get one of these at your local workers' comp office. Sure you can if you look at the small print. Good luck digesting this, and also good luck making heads or tails of it, because it's very difficult to do. Most attorneys don't know how to make heads or tails of it. We do because we practice workers' comp law, but there are many attorneys out there that don't practice workers' comp law. They kind of do it to supplement the income, and that's where you get in trouble. This is a 30C, guys, okay? You can find this on the website as well. Don't get the book, tear it out, and file it. That's not going to count, okay? So this is your 30C. This is you filing a claim for workers' comp, okay? That's what this is. I would say literally 8 out of 10 clients I meet with say, hey, Brooke, look, I filed a claim. No, you didn't. You didn't file one. Yes, I did. I have a claim number, see? And it's like Gallagher-Bassett claim number. I said, no, you have a claim with the insurance company, but you haven't filed the statutory requirements to have a claim under workers' comp. And you only get a year to do that. So this is where people get hung up sometimes. Let's just say you have a claim and, workers' compensation, let's say you filed it with the insurance or the insurance contacted you, whatever, you have a claim number, you think your claim's open. It's probably not. And you're not going to be able to get a hearing until you have a claim opened. And you do that with a 30C. This has to be sent certified, guys, to Workers' Compensation Commission that is local to where you got injured or where you live. And it needs to be sent certified to the employer. Or you can hand deliver it to the employer. Guys, I'm going to tell you, don't hand deliver it to the employer, because if you don't get a receipt and they're shady about that all the time, I hear it from the clients, you're going to really run into some significant problems. Certified mail, it's $7. I think it's like $7 now. When I first started practicing, it was like $4 something. Now it's like $7. Take your $15, send a copy of it to the employer, certified mail, trackable, write down the tracking number in case the green card doesn't come back, and send it to Workers' Comp certified. This should be done within a week. Now, if you're on the fence about hiring a lawyer, your lawyer will do this. It's a legal document, okay? So don't do this if you're on the fence about hiring a lawyer. And guys, I'm going to say this multiple times throughout this video. I absolutely recommend that before you decide whether you're going to handle it on your own or have a lawyer involved, you at least meet with a lawyer, whether it be me or somebody else. It's free. You have nothing to lose. I mean, honestly, you're making an uneducated decision by just moving on yourself, filing your own forms. Don't do that, okay? Meet with a lawyer, meet with a comp lawyer. And meet with a comp lawyer that only does claimant work. The new fad is that these workers' comp attorneys that also represent insurance companies and they represent workers. I don't get it, because I got to tell you, I'm claimant and plaintiff minded. I'm married to a defense attorney actually that doesn't do workers' comp, that does medical malpractice. And I got to tell you, she's cheap. Right? So here's the thing. Defense people are cheap. They are. They're wired that way, which is no problem with that, right? So we tend to overvalue cases as claimants attorneys and plaintiffs attorneys. Defense attorneys and respondents attorneys, they're cheap. Why? Because their job is to mitigate damages to their clients, right? So how that same attorney that's out there at a hearing fighting for the insurance company can represent you as the injured worker is beyond me, because you can't turn it off, guys. If you're defense-minded, you're defense-minded, and you're probably, likely, potentially going to get the shaft. So I would just say, do your research. Research your lawyer. Google Goff Law Group. You'll see I don't represent claimants, or excuse me, respondents, but Goff Law Group. Google. See how many defendants I've represented. None. See how many respondents I've represented. None. Google the attorney you're working with. You might be surprised. See where else they're spending their time. Hey, look at their practice areas. I'll tell you a lot. Criminal, real estate. How I would say to my attorney, well, how much time do you spend on comp versus real estate versus criminal versus this? Because the last thing I want as a client is my attorney calling me saying I'm running late to your hearing because I'm leaving a real estate closing, and by the way, I'm picking up a check from my divorce client and I'm bailing my other client out of jail for criminal court. I don't want that, right? If I'm a client, I want to make sure I'm dealing with an attorney that only does injury and only does this. And that's what my firm does. So again, I'm not trying to sell myself, okay? That's very important to understand that. I'm just trying to teach you guys how to make an educated decision. That's what this video is about. All right, 30C. You have 1 year to file that document, guys, from the date of injury, and it's got to be received. So this is what I'm going to tell you to do. If you decide to handle it on your own, I don't recommend you do that, make that decision without meeting with an attorney. But if you want to not listen to me, which is fine, 90% of people that come in and decide, which is a very small amount, by the way, decide. So let's just say 1 out of every probably 50 end up trying to handle it on their own. So out of those 1 out of every 50, 90% of them return to me after they've just been so beaten down by the system. But let's say you still decide to do it on your own. I'm going to do it on my own. I have the only time on my hands. I'm going to do it on my own. File the 30C immediately, okay? Don't waste time. Don't wait for the year. Just file it. The insurance company only has 28 days from the date of the 30C to file what's called a Form 43, a denial. If they don't, they waive their rights, and that's really bad for them, okay? Because if they waive their rights, the 30C stands. So you could claim in your 30C both my legs, my ankles, my back, my neck, and let's just say you had a prior back or neck issue, I don't know, 5 years before. They can't come around and deny it because now if they've waived their 28 days. So they have 28 days to file a Form 43. You're going to get that probably certified in the mail, okay? Don't panic. It's just a denial. It's a response to your 30C. That's all it is. Moving on. 1A form. File it, okay? Once the insurance company gets involved, you're going to want to get this 1A off the ground. Why? The 1A allows us to calculate the proper comp rate, okay? It asks for what exemptions you have, and then it asks for concurrent employment. Here's a fact that most people don't know. I know that because I meet with many people. If you have a second job, I don't care how part-time it is, and you're paying taxes, that's the thing. I don't want under-the-table stuff. If you, for instance, I represent a lot of EMTs that also work as firefighters, or they work for multiple EMT companies, right? Because a lot of them are per diem or on call. Then what they're going to do is so let's say you only miss time from the one EMT job and not the other, right? The one you got injured at. We calculate your comp rate based on all jobs you were working at the time of your injury, okay? So if you were working 10 jobs at the time of your injury, we calculate your comp rate using all 10 jobs. Why is that important? Because the higher your comp rate, the more valuable your case is. Figure it out now, because then we have to get the second injury fund involved, which we have to do anyways. And we do that all in the beginnings, and then we order the 52-week wage history from your other employer. And guys, it just makes everything go so much smoother, okay? So again, 1As are super important. Remember, you absolutely want to get this filed in the beginning. And I always say file it with the commission because it doesn't hurt you to do that. All right. This is going to also dictate what everybody calculates your comp rate to be. So there's no question, hey, look, we didn't know he had a second job or she had a second job or a third job or a fourth job. And I got to tell you, it doesn't matter if one job you make a lot more money than the other. Let's say you're working for one EMT company. You work 3 days a week or 3 days a month or something. You make, I don't know, $500 a month. But then you have another job as an EMT that you make $3,000 a month. It doesn't matter. The comp rate is calculated based on the two jobs together, okay? And the comp rate is a big pain in the butt. And I'm going to talk about the calculation of the comp rate in a second, but I'm going to tell you why comp rates are so important and how they affect your case down the road. But that's your 1A. File that 1A, get it out. It's very simple. You don't have to know any numbers. All you have to do is your exemptions, a federal tax or withheld, your names, and then get it over to the insurance company, and then you're going to want to get it over to workers' comp, and then you're done, okay? Now comp is your 1A. It's not going to delay anything. Then what happens is after those documents are filed, your employer is going to have an insurance company appear on their behalf. Sometimes they file notice of appearances, sometimes they don't, they just appear. And I will tell you, the adjuster, so your insurance adjuster that's assigned to your file, typically keeps the file if you're unrepresented because they don't want to intimidate you. But just to let you know, there's attorneys working with these adjusters that are telling them what to do and calling the shots. So it's technically you against an attorney. And if there's ever a hearing on your file, an attorney's going to likely show up, not the adjuster. So that's scary, right? Why are you, as a pro se claimant, going to go up against a lawyer? I don't know, but I can tell you right now, one thing lawyers are good at are muddying waters and making life difficult for claimants and respondents. So I want to tell you that one thing you need to understand is it's not you versus your employer. It's you versus the insurance company who has attorneys. So it's really you versus the insurance company's attorneys. Not smart guys. They have a leg up on you right from the get-go if you're not represented. After they appear, you're going to get a notice that they appeared usually, okay? But you can also call comp and see if anybody's appeared. You're going to want to request 3 things. Your first report of injury, which is typically filled out and sent to your insurance company. This is if you're doing it on your own, by the way. If you have an attorney, your attorney's going to do all this for you. This is all done, by the way, in the first 3 weeks of a case. 2, your 52-week wage history. You're going to want to request your 52-week wage history because using that and the 1A, we calculate your comp rate, okay? Very important you understand that. The 52-week wage history is extremely important in that we utilize that to calculate the comp rate. It doesn't go, if you get injured in 2018, it doesn't go, let's say you get injured May 1st, 2018. It doesn't go by what you made in 2017. It goes by May 1st, 2017 to May 1st, 2018. The average of that, then it gets plugged in based on your exemptions into the comp system, then it spits out this number. We use something called comp tools. I believe, and I strongly believe that you have to be an attorney to have this. I know you have to be an attorney to have the software. If you want to try to hand calculate your comp rate, you can. We used to do it. It takes 2 full pages of paper, and by the time you're done, you have no idea where you even started, and you have no idea what you're even wanting to do. So 52-week wage history you need, and that's from all jobs. So if you have concurrent employment, so another job, a second job, then you're going to need to get the 52-week wage history from them too. If I haven't scared you yet, it's going to get scarier, so get ready. Then you want to request any incident reports because you want to know what they're saying about you. You don't want to give any statements to the insurance company. Do not. There's no need to do that. And if you do, you want a recorded copy of it. You want a transcribed copy of your recorded statement because they will use that against you later. Guys, do not give any recorded statements until you talk to a lawyer. I represent a client right now. He had testified that he had coughed at the same time he felt pain. Now they're trying to go after him saying that he had a cold and it wasn't work related. Come on. This is like a come on man moment. Any of you football fans. Are you kidding me? Really? A cough can herniate a disc in the back, sure. But it can't. But now my client hasn't been paid for weeks. He retains me. Now we're fighting about it in comp. Do not give recorded statements, okay? Meet with your lawyer. The lawyer will handle it all. There's no requirement to do so, and they'll leave you alone after you get a lawyer. And if you choose not to get a lawyer, you will give a recorded statement, unfortunately, because they're going to probably talk you into it. But make sure you request a copy. Comp rate calculation. Super complicated. I just told you. It used to be 2 or 3 pages long. Now we have comp tools. So you're going to get I'm going to tell you how this is going to go. You're going to get so tired by trying to calculate your comp rate, okay, that you're 2 or 3 pages long and you're trusting the employer's number, that you're probably just going to trust what the adjuster tells you it is. Let me tell you, when I was a baby lawyer and I first started, I was okay, let me test every adjuster's number. I want to see if they're right? That's key. Do you know regularly, when I say regularly, I don't mean 1 in 100. I mean 1 in probably 6. Comp rates are wrong because the adjusters undervalue the comp rate. Do you know how crazy that is? And sometimes by $30 or $40 a week. That's insanity, okay? So now I have a client that comes in. He's been representing himself for 26 weeks. He's been underpaid by, I don't know, let's just say $100 a week. That's $2,600. I got to tell you, oh, great, George. I'm glad to hear that. Anybody that sees what I'm saying, I'm not just talking to myself. One of my clients had suggested something here, and I appreciate that, George. That's crazy. $2,600 is a lot of money. If you're on comp and you're already not getting full bow, that's horrendous, okay? You don't want that to happen to you. Don't be stupid about it. And do not trust the adjuster's number, guys. They work for the insurance company, right? They get bonus based on how much money they save the insurance. Their benefits, their pay is based on the insurance, okay? Why you would trust somebody that has a self-interest in you being basically your damages being mitigated, I don't know. It's the same reason I question clients as to why they're so trusting of jurors. I wouldn't trust 8 jurors if I don't care who you are. Why? Because you don't know what they've been through, and you don't know what their goals are, right? We can question them all they want, but people that have some issues can cover things up pretty well. So adjusters, guys, these people that are calculating your comp rate that you're gonna, you're going to trust, right? They're people that don't have your best interest at heart. So I would not trust them. Again, your attorney, a good comp attorney, has comp tools. They spend the money because they do technology like we do, modern day personal injury law firm. Some attorneys don't. The first question I'd ask a comp attorney when I went in there, I would say, what's comp tools? If they look at you like you have 10 heads, run, because they should know what it is, all right? Nobody should be doing this hand-calculated stuff. You're opening yourself up for error, and it's not necessary, and it just shows that they're not willing to invest in their firm, which is a bad thing. My opinion, just my opinion. Also, after, let's say you figure out the comp rate. Let's say you hired me and we figured out the comp rate, right? Then we request what's called a jurisdictional VA, jurisdictional voluntary agreement. They're green. Do I have? I'll show you the color that they are so that you can see. So they come on paper like this color. This is blank, but something like that, okay? You get 4 sets of them. That says that we've agreed on your comp rate. That's what it is. And the commissioner's gonna approve it. Now we know you're not being underpaid for a long period of time. We don't have to go beat somebody down to get, beat an insurance company down to get you the right pay. And now we know you're getting the right amount of payment, and it's gonna follow you throughout the case. It's clean, guys. Clean is key. Comp equals clean, okay? You want to be clean, the file clean if you're in comp, because you want to really set it up for either settling it down the road, way down the road after you resign or retire, way down the road, or if you decide that if the doctor says you can't go back to work, you want to set it up for settlement on the near future, or if you just choose to resign or retire earlier, you want to make sure it's set up for settlement. So that's your calculation of your comp rate. Now we've covered voluntary agreements, okay? So let's talk about benefits for a second. I'm not going in any particular order. There's 3 types of benefits in workers' comp. Temporary total benefits. I can't work. My doctor's keeping me out. I have no work capacity, okay? These are benefits you get paid from workers' compensation. This is, these are benefits that when they file a Form 36, typically they're trying to end these benefits. These benefits can be endless as long as your doctor's keeping you out of work and saying you're not at maximum medical improvement, okay? Then you have TPD benefits, temporary partial disability benefits. What does that mean? You're light duty, meaning you can maybe do 4 hours on, 4 hours off, or you can only work half days or whatever the case might be. That's TPD benefits. Typically, you go from temporary total, TT benefits, to temporary partial disability benefits, TPD benefits. That's typically what we see, okay? And sometimes TPD benefits, if your employer can't accommodate your restrictions, 4 hours on, 4 hours off, or whatever the case might be, can't lift more than 10 pounds, then you'll have to do something called a light duty work search form, which may be in here. I'm not 100% sure. If not, you can always Google this and see. The insurance company will not tell you always that you need to do these forms, as it's not their job to do so, right? So if they don't tell you to do that you need to do these forms, you don't do them, all of a sudden you'll be TPD, right? And guess what? Your benefits will stop. That is right. They will absolutely stop. You're going to be mad because you're going to say, wait a minute. I didn't know that they wanted me to do these things. Yeah, there's not one in the book. Sorry, guys. I didn't know they wanted me to do these work searches, right? Use the form online. By the way, please use the form. Don't do your own. Don't write a graph, Excel, whatever. Just do the form online. It's easy. If you don't do these work searches, you're all of a sudden going to realize you're not getting checks. 4 weeks go by, you go, guy, you're a nice person, so you're not going to bother anybody. You're like, comp, I'm handling the case myself. I'm not getting checks. What's up? And they're like, well, we're not getting work searches. That's a problem, right? Huge, huge, huge problem. Because guess what? They're going to say, you should have known, but it's not my job, or you should have, you ready? You should have had a lawyer, right? And comp is not very sympathetic to this type of thing because now the 36 is approved and they can't really do much about it. Again, light duty work searches have to start the day that the 36 is approved, which is the day that it's received. So let's say your doctor puts you at light duty from full duty, okay? You're going to get one of these certified mail, all right? This is called a Form 36. Looks just like this. See? And it's going to be certified. And you have to object within 15 days. If you're a pro se party, typically commission will put it down for a hearing. Pro se meaning you represent yourself. If you have a lawyer, the commission makes the lawyer request a hearing, right? Which is no problem. We do it all the time. So then you file for a Form 36 hearing, right? Fine. And you tell the commissioner, let's say it's from TT, can't work, to now light duty work. The commissioner is going to grant this 36 based on the date of receipt. I always go to these hearings because I want to make sure that they actually date it correctly because I don't want you to lose out on even a couple days of benefits. It's stupid. Why would you? Right? That's my job. So this is when the late duty work searches start. And the commissioner should tell you that. If you don't go to the hearing, they administratively approve this, which means no hearing, and they approve it. And then it's up to you to do the work searches. Guess what? If you don't do them, you don't get paid, like I said. Then you have PPD benefits, permanent partial disability benefits. What is that? Your doctor has found that you've reached maximum medical improvement, and now you're given a rating, okay? Your benefits switch over from either TT or TPD now to PPD. PPD benefits are not endless, guys, okay? PPD you're given based on the impairment rating that the doctor assigned your body part. If you have a back, for instance, you hurt your back, well, not if you have a back, but if you hurt your back, and let's say the doctor gives you a 10% rating, that's equivalent to 37.4 weeks. If you have a comp rate of $1,000 per week, that equals $37,400 per week. Paid out at $1,000 a week over, ready, 37.4 weeks. At the 37.5 week mark, guess what, guys? Your benefits are done. Out. No more, no pass go, no collecting $200, you're done. Many people say, okay, well, I'm still treating with a doctor. If I'm still treating with a doctor, how can they do this? Because they're only responsible to pay you as long as you have a work capacity until you reach maximum medical improvement, which is the PPD stage. You're going to get more of those green pieces of paper, but they're going to have the rating on them. They're going to have your comp rate on them, which you've already agreed to because you did jurisdictional VAs like I told you to. And then you're going to have the amount of weeks on it because the weeks come out of this book, right? So back's 374 weeks. Neck is 117 weeks. And then you have legs, you have arms, every body part is rated, okay? So that is the point where you should start getting nervous because your benefits are going to run out, okay? Now at this point, if the doctor says, hey, look, he has a 10% impairment of his back and he can't return to his job, your employer might say, we can't accommodate you at your job. You now don't have a job to come back to. Not because you're injured, but because the doctor told you couldn't go back and they can't reasonably accommodate you in another position. You're literally looking down the barrel at 37.4 weeks until that's it. Benefits are over. They will not pay you another dime. So this is the perfect time to try to settle your claim once you get your rating. A good lawyer is going to try to do that for you. Doesn't guarantee because workers' compensation does not have to settle. By workers' comp, I mean the insurance company doesn't have to settle. Workers' comp commission can't look at an insurance company and say, you must settle. They try to, obviously, encourage settlement, but they don't have to. You cannot settle your comp case if you continue to work there. You must resign. Okay? Now, if the doctor says you can't return back to that job, it's very easy to resign, right? Because you can't return back to the job anyways. But if for some people that are planning on going back to the job, to settle, you must resign. Take anything from this. I always get people saying, okay, can I settle against my employer? Not if you plan on working there. Well, and I always tell people, don't just settle a case to give up your job. I mean, if you can't do it or you don't like your job or whatever the case might be, sure. But there's no amount of settlement money that's going to make up for a very good job and benefits and pensions and all that other stuff. So don't do that. But if you can't return to your job or you weren't happy with the job or you found another job or whatever the case might be, guys, it's easy. At the point you get rated, now that gives us 37.4 weeks to try to work out a settlement, right? And the leverage is in your ballpark because now they owe you these PPD benefits. So now they want to get rid of you. It's kind of like a mindset. It's a weird psyche thing. They think, I'm going to somehow save money settling when he's getting his PPD, which is absolutely not true. They always pay me more. But this is the perfect time to settle a case in the event they want to settle. Rarely do I get insurance companies saying they don't want to settle. It does happen, especially if they want the person to come back. But if the person doesn't go back and they want to resign, then we settle it. Doctors, okay? Next topic, doctors. You get to choose your own doctor. I don't care if they tell you have to treat with our doctors where I send you. Wrong. Now, if you work for Harvard Healthcare, Yale, some other facilities, they have a preferred provider network that you have to choose from those doctors, but there's many of them. It's not like you can only choose one doctor, but you still get the choice, okay? So one question I would ask in the beginning of a case if I were a client that is set on representing yourself, don't recommend it, is, hey, look, are we part of a approved provider network or do we not have an approved provider network for workers' comp? If you don't have an approved provider network, you can choose anybody that does the specialty that you need. In the event that you do have an approved provider network, Harvard Hospital, Yale New Haven, whatever the case might be, you must go with their approved provider network. And I'm telling you, they hold on to these things. They're actually kind of a pain in the butt about it. You got to squeeze it out of them. So I always, especially with a Yale New Haven or Harvard Health, I always move for a hearing on an emergency basis on medical treatment so I can at least get it, so I can make sure that we're not chasing the 8 ball down the road and my client doesn't feel comfortable and gain a relationship with a doctor that now they can't treat with because they're out of network. That's bad lawyering, okay? You don't want to do that. Now, it does happen, guys, okay? So if you can't get the list, I'm not going to make my client wait for a treatment. I'm going to send them to wherever they are and we'll deal with it later. But most of the time, this is what we like to see. You get to choose your own doctor. Do not fall for you must treat with our doctors or we're not going to pay for it. They're lying to you or they don't know what they're talking about. But again, It's you versus an insurance company with a lawyer if you're by yourself. So, I mean, who knows what to believe, right? This is why I always say, meet with an attorney, then make your decision. Mileage. They must pay to and from doctor's appointments for mileage. Right now, the federal rate's like 58.5 cents. It's huge. So if you figure if you go to the doctor 50 miles and come back 50 miles, you're at $58.50 every appointment. Do these monthly, start them. They're worker. Do they have one in here? Probably not. They don't have the work search. They definitely don't have the mileage form in here. However, you can get them online. So you print that, you go to mileage form and you print it from the internet, and I would say put these in every month. Your attorney should help you with these if they have one. If you have one, excuse me, and they'll help you with your mileage. They'll get the bills. They'll make it so that you get reimbursed for the mileage. You have to work together with the attorney because you know where you went when you went. However, your attorney, a good attorney, will work with you. Guys, if you meet with an attorney that tries to send you on wild goose chases for things, that's not what this is about. So attorneys have lost this idea that we work for the client, right? And they somehow think that the clients owe us something. Not the case. If I were a client and an attorney made me feel that way, I would say go screw and I would move on. Because why? Attorneys in Connecticut, there are many of them, tons of them. Now, I think we all bring something different to the table. I'm not saying we're all equally footed. However, sorry, I had to block a call through. You're only going to benefit from not getting an attorney that focuses on comp and not getting somebody that you just heard about or what have you. And the one danger can be if you choose an attorney that doesn't do comp, but your buddy sent you there and like your buddy knows them. Let me tell you, when you have a bad experience with an attorney, you're going to be really mad at your buddy if they sent you there. So I'm not saying don't go. I'm saying do your research on the attorney before you do it. Don't just assume, my buddy told me they were good, so I'm going. Don't do that. Do your research. Make sure it's a good fit for you. All right? Mileage, yes, they have to pay you to and from. Doctor's appointments, if medically necessary, you break your leg and you can't drive, then they have to pay for a taxi or an ambulance to bring you to or from your doctor's appointments. Most people don't know that either, which is super, super important. So guys, again, settlement, I'm going to go through with you real quick. So you could get your PPD. Remember what the PPD is, right? Trivia question, PPD. That's your impairment rating. Then you can get something called 308A. I can't return to my job and do the job the way I used to be able to do. So now I'm moving for 308A benefits, which can only equal the amount of the PPD total, okay? PPD for each body part added together total. That's if you injured more than one body part. Then it's 308, I call it AB. Every attorney calls it differently, which is an increase in your rating over time. So if it's a 10% rating, I always ask for at least 60%. So, if it was a $10,000 benefit, we'd bring it down to $6,000 for 308AB. And then we do future TT, future time this person's going to miss from being out of work in the future, okay? Then we do future medical costs. Now, this is tricky because, you have to work with some doctors will be like, this person's not going to go need medical care again. They can't tell that, right? So you have to rely on an attorney to know what fair and customary medical treatment would be, the cost, etc. Again, this is important. You never want to jump to settlement in the event that you're going to need something significant in the future. But you also don't want to keep your case open because you're afraid you're going to need something. So if you're keeping your case open for, let's say the insurance company offers you money, right? Or offers me money for you. And you're like, Brooke, I might need, future chiropractic care later or whatever the case might be, right? Don't keep your case open for that reason. This is not legal advice. This is just me telling you. You can take it for whatever you want. Because here's the deal, guys, all right? And every case is different, so I would say I'd want to review each case. But the problem you're going to run into if you do that, right, is that this could be the only time you're ever going to see a lump sum of money. And let's just say you never need the future maintenance. Or let's just say, down the road that you get injured again at work. Now you've lost any leverage you have. I've had clients, I've had clients turn down because obviously I want to do what that makes them comfortable, regardless of my advice, 30, 40 grand. 2 years later, they call me, they're like, let's just settle it. The insurance company's like, the money's not on the table anymore. When you hire an attorney, you rely on our expertise, but you have to feel comfortable with what we're telling you. So you need to be comfortable with your attorney. Don't just sign papers and not talk to them or know them, because let me tell you something. You want to make sure you're not dealing with an attorney that's so desperate for cash that they're going to push you into settlement because they have their own best interests at heart, right? You can't do that. You don't want to do it. Don't do it. All right. You want to make sure you're dealing with an attorney that has the case on what's not based on what's best for their paycheck or their ability to pay their bills. You run into this. Personal injury, guys, can be feast or famine, right? And a lot of attorneys, unfortunately, in this area are not great with money. Luckily, we've been very fortunate in my business to not run into these issues. But I'm telling you, it plagues a lot of firms. And you want to make sure that your case is being handled by an attorney that's not making decisions based on them and their needs, but it's based on what's best for you. If you ever feel pushed into settlement, now, after the attorney explains to you what's going on, if you ever feel pushed into settlement, that's a problem, okay? And it's definitely an issue that you want to have a second opinion on. But I'm telling you, typically with settlement, once there's a settlement offer on the table, if it's a good one, I always bring my clients to the commissioner. I'm like, Commissioner, look, explain to this client, please, because I want to make sure they understand that what this offer means, and that it's a good offer. And guys, I get great settlements on comp cases. Why? Because they know I know what I'm doing. And they also know that I know how to value a case, right? But some attorneys don't. This is the other issue you run into. The commission knows, and the insurance company knows, the good lawyers from the not great lawyers, and the inexperienced lawyers is probably a better word. And you don't want an inexperienced lawyer. You don't want to be the best case in your attorney's office. That's dangerous. So I've thrown tons of info at you guys, right? Tons. And I'm going to tell you that I don't expect you to retain all of it, but your head's probably spinning, and it should be, because that's workers' comp. It makes everybody's head spin, including mine sometimes, right? We try these issues. And you need to know that this is the kind of stuff you're facing if you choose to handle the case on your own, which I do not recommend. I get contacted by their attorneys saying, what are you doing releasing these videos? You're going to give people reason not to hire lawyers. I actually think the opposite, and it's been the opposite. I think you're showing clients why they need a lawyer, and you're allowing them to make that educated decision for themselves instead of feeling forced into it. Your level of comfort is my key. And like I said, and I stand by this, I want my clients to hire me because they want to hire me, not because they need to hire me. And I do so well in this business because that's the kind of relationship I have with my clients. We communicate effectively. We utilize technology to improve your lives, and we win. And we win because we invest heavily in ways to make your life easier and cases move faster. Again, guys, I appreciate everybody watching this video. I encourage you to share it because let me tell you, the statistics say most people are going to be in a work-related injury at some point in their lives, and you're definitely going to want to make sure that you have the right lawyer on your side to help fight the good fight, because let me tell you, if you don't, there's not much of a fight to be had, and the commission will tell you that. If you want to reach me directly, you can call me 203-399-0000, option 1. You can email me at Brooke, BROOKE, at gofflawgroup.net, GOFFLAWGROUP.net. You can Facebook us, which I hope now you will add yourself to our Facebook network. I release these videos all the time, and they're so people just love them. I give so much information out, and I'm happy to do it. It's my favorite part of my job. And you can also text us. So we have a texting platform here. It's a fully secured texting line. It's 203-399-0000, just like the phone number. Guys, thank you. I hope everybody took something away from this video. And I hope, if anything, I've helped all of you be able to make the educated decision that you should make, which is to obtain legal counsel in the event that you're ever injured at work, to not only protect yourself, but your families and your future. Thanks. Have a great night, guys.